Today's presentation of Administrative Rules, Resources for Municipal Civil Service Commissions. This presentation is provided by the State Personnel Board of Review as part of its ongoing mission to provide quality information and resources for municipal civil service commissions throughout the state of Ohio. Our presenter today is Mr. Ben Albrecht. Mr. Albrecht is a partner in the firm of Fischel, Downie, Albrecht, and Riepenhoff. In his practice, Ben advises cities, townships, counties, and public officials throughout Ohio on labor and employment law issues, including the preparation of Municipal Civil Service Commission rules, employee handbooks, and policies for various jurisdictions. Ben has conducted numerous seminars, presentations, and leadership seminars on a variety of topics. We're so fortunate to have him with us here today, and with that, I'll turn things over to you, Ben, and we can get started whenever you're ready.
Thank you. I appreciate the introduction, and I appreciate the opportunity to be here today. And whoever's watching online, at whatever point you're watching, I'll say good morning, good afternoon, or good evening as we engage in our fireside chat about civil service rules and civil service commissions and administrative rules. Today's presentation and today's materials are going to provide a basic groundwork of things that you're going to want to consider during your time on the Civil Service Commission. In particular, we're going to talk about the importance of periodically reviewing and updating your rules, why that's important, what are some of the things that you consider in updating your rules so that you have a rewarding experience on the Civil Service Commission. So with that being said, we appreciate your participation today. And with that, we'll dive right into it. So as I mentioned, we're going to cover a broad spectrum of topics today. And if you've served on a Civil Service Commission for a period of time, it may be somewhat not new material, I guess we'll say. But if you're new to the Civil Service Commission, there are probably some terms and some powers that I'm going to use today that are going to be new to you. So we want to make sure we understand that. So for those of you that are new to a Civil Service Commission or are needing a refresher, we're going to talk a little bit about the powers, duties, and responsibilities of the Civil Service Commission today. And one of the important things that everybody should understand is that as a Civil Service Commission member, you may be tasked with hearing an appeal from an employee relative to a disciplinary action, relative to a layoff, relative to an assignment or a reassignment to a new job classification. And you are going to be tasked with determining whether or not that decision was appropriate and consistent with your rules. So all of these things are going to tie together. And when you hear these appeals from employees of an action of an employer or of the appointing authority, it's going to be important for you to understand that as a Civil Service Commission, you will have the authority to affirm the action of the appointing authority. You'll have the authority to disaffirm it, or you can modify it. So there's a lot of flexibility that comes within that. But throughout the process, you want to make sure that your rules are being adhered to. And that's why when we talk about one of your powers being the ability to adopt rules, we need to make sure that when we periodically review these things, we're gaining insight from our counselor about what are the legal requirements and obligations, what have been some circumstances that have occurred in the past that maybe warrant a change in the rules, or what type of flexibility that we can provide. Because it's going to be one of the things that's important is to make sure that we provide ourselves sufficient flexibility to deal with things as they may change over time. So we're going to want to consider a lot of those things. And it's important to understand from a big picture, what is the purpose of civil service in Ohio? And that's something that is set forth in the Ohio Constitution to make sure that all appointments and promotions in the civil service of the state, several counties, and cities shall be made according to merit and fitness. So we want to make sure we're not doing anything that may result in the classic spoil system that we've heard about over time, that these decisions in the civil service, at least as the classified employees, are done according to merit and fitness. So we want to understand what those terms mean, which brings us to another thing that we're going to talk about today. Generally relevant terms that Civil Service Commission should be aware of. Not everybody has a background in civil service law. Not everybody on a Civil Service Commission has experience working in the public sector. And there are a lot of terms that may come up on occasion that you're unaware of because they're unique to the public sector. So we want to understand what is the civil service? And generally that includes all positions and offices of trust within the city. So the civil service is a broad spectrum of all those positions. But within the civil service, there are two classifications of employees that may impact appeal rights or rights of the employees within the civil service. So it's important for you as a commission member to understand the distinction in those terms. One term is classified, and classified employees hold their position for what is known as just cause. And we'll talk a little bit about what just cause is coming up here shortly. But those classified employees are going to have certain rights and privileges under your rules. Then we're also going to talk a bit about unclassified employees. And those employees, if you're coming from the private sector, are similar to at-will employees. They're going to serve at the pleasure of their appointing authority and may be disciplined or let go for any reason or no reason, so long as it's not an unlawful reason. But again, whether someone is classified or unclassified has a big role in what are their rights under civil service law. So we're going to talk about that. It's also important to understand who is the appointing authority for the city. And it's going to be important to understand that because they're the ones who ultimately make the decision that you're hearing the appeal of. So it's important to understand, is it the city manager? Is it a safety director? Is it a service director? Or is it somebody else? Is it the mayor? We need to understand who that is and how that is set up, because that's ultimately whose decision you're going to be reviewing and considering. So there's going to be a lot of issues we're going to discuss today. Hopefully it's not overwhelming. And certainly if these issues do come up and you are a little bit overwhelmed, please do reach out to your local advisor to make sure you're getting your questions answered so that there is no confusion. Because again, it should be a rewarding experience to serve your community, not something that is overwhelming to you. So make sure you address those things. The Civil Service Commission, we've already touched upon that a little bit about who you are and what you do, but let's talk about what your abilities and responsibilities are. And you do in civil service law have the ability to implement and amend your own rules. And again, this is something that you should do periodically to make sure that your rules are accurately reflecting what you're experiencing within your community. And there's some specific things that we're going to talk about that periodically have required civil service commissions to maybe address what some of their thoughts are as far as what their rules should be or how their procedures should play out. And if we could move back one slide to address a few things on some of the terms, I want to touch upon a few different things about the civil service generally. But again, civil service covers everybody who's in the employ of the city. But then within those positions within the civil service, they may be classified, they may be unclassified, they may be exempt from various provisions. And in determining whether or not someone is in the classified service, for example, you may need to look to a broad spectrum of things. Maybe you need to look at your city's adopted personnel code. Maybe you need to look at the charter, if there's a charter provision that governs that, because those are provisions that are going to come into play. We also want to understand just cause. What is just cause? Because if you're serving over or presiding over an appeal of discipline, that is the standard that you're going to review. So we need to have a basic understanding of what just cause is. And as a very basic principle, just cause is whether or not the employer had a rule. So did the city have a policy? Did they have a standard of conduct about about the misconduct or to govern the conduct? Was the employee aware of that rule? So did the city do that which it needed to do to educate the employee on the expected standard of conduct? Then did the employee do an investigation to determine whether or not the misconduct in fact occurred? And as a civil service commission, you are not a court of law. It's an administrative hearing. So that's one of those things when you go to weigh the evidence, it does not have to be guilt beyond a reasonable doubt. It's not a criminal matter. It's usually a lesser threshold, usually a preponderance of the evidence. which means just a little bit more than 50%. But again, that may be something that whoever is presiding over or prosecuting the matter is going to present to you as far as what the appropriate burden of proof is. And then lastly, what is the appropriate level of discipline? Does the discipline warrant a 5-day suspension? Does the discipline warrant a demotion? Does it warrant termination? And that's something that's relevant probably in your rules as well, as what level of discipline can be appealed to you. In Civil Service Law 12434 that would go to the State Personnel Board review, say for a county employee or certain other employees, there are certain levels of discipline, certain levels of suspension that cannot be appealed to the Personnel Board review. So you want to make sure you're checking your Civil Service Commission rules as well, your personnel code, excuse me, or even your charter to see if there's anything that limits what can be appealed to you. Another issue that may come to you may be a layoff or a job abolishment. Unfortunately, jurisdictions on occasion have to lay off employees. Generally, it's for a lack of work, a lack of funds, a reorganization, an abolishment, or something along those lines. And there's going to be very specific procedures and requirements that employer is going to have to walk through to justify the decision to lay off employees. And that's something that you as a Civil Service Commission member are going to have to make sure that you can confirm that the employer did in fact meet its obligations under the rules or under the law to address those issues. So with that being said, those are some of the things that you're going to have to look at along the way, or potentially may have to look at. And within your rules, you're going to have other definitions or other terms that you're going to have to understand. But these are some of the big ones that come up rather frequently within doing civil service law or civil service issues. And if you skip ahead to catch you back up a couple slides, it's rules of CSCs often include. When you go to review your rules, if you go one more slide. There you go. So if you go to review your rules or adjust your rules periodically, it's important to understand what are the types of things that are generally in civil service rules. What are the types of things that civil service commissions typically utilize in doing their jobs as civil service commission members? And one, definitions. Definitions are always a big thing so that you know who is involved, what its specific term means. And if you look at Chapter 124 of the Revised Code, which is Ohio Civil Service Law, there are samplings of definitions that you can consider that outline various things. But again, that's something you're going to want to confirm with your personnel code or your charter provisions to make sure that you're not implementing any rule that is inconsistent with one of those types of provisions, because we will talk about the charter and the role it plays relative to other rules and laws out there, maybe even a collective bargaining agreement. We'll talk about that a little bit coming up too, about what impact those have on your rules. Classified versus unclassified service we've already discussed, but it's important to understand and make sure your rules clearly delineate what that means. In the unclassified service, you may have a charter provision that outlines very specific positions who are in the unclassified service. Typically, your department heads are going to be in the unclassified service and serve at the pleasure. But there may be also certain fiduciary or administrative employees or other employees that are going to be referenced in your civil service rules, and there should be some explanation as far as what that means. And again, there's a whole series of case law out there explaining what those terms mean and how far back in time you can go to review duties to determine whether or not someone is in the unclassified service as a fiduciary. For example, the administrative rule that the State Personnel Board review tends to rule is generally 2 years. You go back in time to see what those job duties are over a couple years. So consider having those types of terms so that you can fully evaluate an appeal or in a matter before you. Probationary periods. Probationary periods serve to allow the employer to effectively get rid of an employee that's not working out. They don't have appeal rights to the Civil Service Commission, and they can be let go during their probationary period generally for unsatisfactory work performance. But one of the things that the city can do, and may be included within your personnel code or within your civil service rules, is how long is that probationary period? It can generally be up to a year, but that's something that's going to be important for you to understand when you get an appeal from an employee. Are they appealing within their probationary period? Because then they wouldn't have standing. But if they're outside their probationary period, then they would have the ability to file an appeal to you. So that's a term that you need to understand and you need to be aware of when you're faced with an appeal from an employee. Employee types, again, that's something else you may want to consider outlining within your rules. There are classified employees, there are unclassified employees, there are temporary employees, there may be temporary appointments. There's a lot of things that you can set forth in your administrative rules, again, which may govern certain types of appeal rights or may also limit the actions of the municipality over which you preside on the Civil Service Commission. So those are things you're going to want to look at. Class plans. Those generally encompass all the job classifications within the city and may include information relative to pay and those types of things. And it's important to have an understanding what is the class plan because you may be tasked someday with determining whether or not a layoff is appropriate or an abolishment or how bumping rights within positions come into play. So you're going to want to understand what those classification plans are. Or if you're dealing with a promotional issue, those are types of things that you need to understand what that term is, or at least have a general understanding of it. Position descriptions, I think we all have a pretty good understanding as to what a position description is, but those are going to be the forms that outline the general requirements of a position, as well as outlining the essential functions of the position. Relevant on some appeals of discipline, relevant on certain types of reclassification appeals, or those types of things that you may have to deal with. You may be tasked with determining what position is an employee actually serving. Job description, your position description are going to be critical in helping you reach that determination. So again, understand what those terms are, understand what their role is, in the event they're handed to you during the course of an investigation, or I'm sorry, not an investigation, but during the course of an appeal, to make sure that you're on the same page with everybody else. Now, moving on to the some of the other things that are considered by a Civil Service Commission, exam process. And again, as a Civil Service Commission, you're likely to have a role in the hiring process. You're likely to have a role in the promotional process, in that you are probably going to help set up the test or set up the exam and approve an eligibility list from which an individual can be appointed. So that's something, again, that when you set up your rules regarding the examination process, many times people hear examination process and they think a written test, or they think that there's some type of fill in the dot test. But it's important to know under Ohio Civil Service law, there's great flexibility as to what that examination process may mean. So you're going to want to look at your rules or your administrative rules as to how that plays out or how you're going to score that. But a municipality could have great latitude as to whether it's an oral exam, a physical exam, some combination thereof, an assessment center, a demonstration of skills, an evaluation of training, capacity, knowledge. There's a whole host of things that are often to be considered or can be considered when giving an exam for a various position. And sometimes it's helpful to have that latitude in determining what is an appropriate examination because a certain type of examination may be more appropriate for one classification or one position than another position or classification. So again, look at your rules and how those rules are set up to allow your jurisdiction to do a testing process to give it the greatest latitude to find the best candidate possible. Now, again, when you do the examination process, the purpose is to find the, make an appointment based upon merit and fitness. But again, the bigger flexibility an employer may have in making that appointment should help you find a good, solid candidate. Now, when making the appointment, you'll make that an appointment generally from an eligibility list. And what the eligibility list is you take the top highest scores on the exam, you put them on an eligibility list, and the employer appoints from that list. And it's important to set up from your rules, how are we going to appoint? Are we going to appoint from the top 25%? What if there's a certain number of employees or applicants who submit an application for a position? How do we make that work? You can set all that up by rule. You can set that up by your civil service rules or other types of rules within the organization as to how you're going to appoint those candidates. It's generally speaking, that eligibility list expires upon appointment to a vacant position, but there may be permissive reasons for extending the life of that eligibility list for a longer period of time. And again, that's something that civil service law allows you to do. And if you're looking at how you're going to set that up in your own local rules, that's something you may want to consider. And as far as the scoring process, there are opportunities to provide candidates additional service credit. Military service is an important credit that many employees who have a prior military background or many candidates may be eligible for. So you can set forth in your local rules as to how much is that extra credit going to be, how do they get that extra credit, make it clear that they have to obtain a passing score on the exam first before they're otherwise eligible for it. But you can set forth all of these rules, all of this guidance on these eligibility lists and appointment process. What are the different appointments? Who's subject to a competitive exam? Who's not? Like I said, who's a fiduciary? Who's an unclassified employee? That can all be done on a local level, either through your civil service rules or your board's administrative rules. So those are things, again, that you're going to want to consider to look at and periodically update. The law doesn't change too frequently, but periodically it does. I know several years ago there were some changes to these processes that, again, that on a local level, you always want to make sure your rules are up to date. You know, I had a situation once on a scoring issue with the Civil Service Commission that hadn't reviewed their rules in some time, and they joked that they were still giving credit out for people who served in the Spanish-American War. Now, I don't think it was quite that far back in time or been that long since they had updated their civil service rules, but it did go back in pretty good time. And I guess if people are aware of the Spanish-American War these days, they should get a little extra credit. But that's just an example of sometimes these sit off to the side a bit too long. Some other things, some other rules that may be included within your rules relative to layoffs and job abolishments. And again, the municipality is going to have the ability to lay off employees for things like lack of work, lack of funds. They can abolish positions. And within your rules will be procedures that appointing authority must follow in doing those layoffs or doing those job abolishments. Those can be appealed to you. So you want to understand how those rules work to make sure that that employee has been afforded the appropriate notice of the layoff or abolishment, that the employer has filed or submitted any paperwork that's necessary and appropriate, that that employee has had the opportunity to bump down to another classification if appropriate, that those bumping rights were determined appropriately. So there's a lot of things that go with the layoff and job abolishment for classified employees that are going to be set forth in your civil service and your administrative rules that you're going to want to review to make sure that the appointing authority has adhered to the appropriate requirements and responsibilities. Because if they have not, that's something that should probably be disaffirmed or modified depending on what the employer has done. So you want to have some familiarity with that, and you should probably review your rules periodically to make sure they're clear as to how that plays out. An issue often comes up when we're doing a hearing before a Civil Service Commission member, before a board, I should say, because Civil Service Commission is, what are our powers relative to a subpoena? Can we compel the attendance of witnesses or documents? And the answer is, if your rules allow it, yeah, you can do it. That's generally something you as a Civil Service Commission would have the power to do. I would set that forth in your rules so that there's no confusion about it, and set forth within that subpoena power, what exactly does that mean? Can you compel the attendance and testimony of witnesses, or do you just simply compel the presentation of documents and information? But put that in your subpoena power language to make sure that everybody understands what that is. Because many times if you're doing a hearing One of the things that the party representing an employee or party representing your jurisdiction may ask is for you to subpoena a witness. And it's just a lot cleaner to make sure that that's included within your rules, that you have the responsibility and the authority to do that. Political activity. There are certain restrictions in Ohio law relative to what classified employees can do with respect to partisan political activity. If employees in the classified service engage in partisan political activity, they may forfeit their right to continue their service for the city. So many times administrative rules of the Civil Service Commission may outline what it is that a classified civil service employee can do and what they can't do when it comes relative to partisan political activity. And if somebody wants guidance on that as far as what can be done or what is prohibited for a classified civil service employee, there's an Ohio Administrative Code provision that sets forth those responsibilities or requirements pretty plainly that you can use as a guidepost for your administrative rules. Another issue that often comes up that you may be tasked with hearing about is what's known as a disability separation. This arises when there may be an employee that has an illness or an injury that may be long-term. Maybe they've exhausted all of their paid leave, their sick leave, family medical leave if it's appropriate, and the employer wants to take steps to separate that employee. So if the employer has information, medical information that's reasonably reliable that the employee is incapable of performing their essential functions and is going to be incapable of performing the essential functions of their job for a period of time, they may engage in what is called a disability separation. Pursuant to the existing administrative code, it could be either a voluntary disability separation or an involuntary disability separation. But that's something that you may want to put within your rules or consider having within your rules to set forth that process as to how it plays out. For example, the employee generally has an opportunity to respond to the medical information about whether or not they're capable of performing the essential functions of the job. So it's kind of a pre-separation hearing. Many times there's a reinstatement period for that employee if they're capable of doing the job. So those are types of things that you can set forth within your rules so that everybody understands what their obligations and responsibilities are when they're faced with those types of situations or faced with making those types of decisions. There's a lot more that could be put in your administrative rules. There are a lot of things that come up, and I would encourage you that as an issue comes up or someone within the city has an issue, because you'll likely have to adopt those rules. If you're presented with an updated rule or a change to a rule, or someone has a question about whether or not it's appropriate to include such a rule within the Civil Service Commission's rules, ask the question. Ask, why are we including this? What is the legal requirement? What is best practices? What does the Ohio Revised Code say about it? What does the Ohio Administrative Code say about it? Because those are all things that may be helpful or provide, again, good guidance on what you may or may not want to consider having in your rules. Now, as far as some of the things that relate to the importance of your administrative rules, one, they're nice because they help you do your job. They help guide you through the process, sometimes a process that isn't necessarily known to people. But the other reason it's nice to have those types of rules in place is because you have a filing requirement with the State Personnel Board of Review. So when you look at your statutory provision, you're required to submit a yearly report outlining the manner in which the law and the rules and regulations under it have been and are being administered. So when you do your annual filing with the board, your administrative rules will help to make that process easier. So that's the other reason we want to periodically look at it and make sure it's updated and allowing us to do that which we want to do or that which we may need to do. Some other considerations that you may want to look at when you go through and revise your rules and review your rules. One, look at your municipal code. There are probably personnel code provisions within your local ordinances Make sure you're reviewing those so that there are no inconsistencies between the two. Many times, a municipality may review the personnel code or specific provisions related to employment and not even think about updating the administrative rules governing the Civil Service Commission. So that's something that you want to take those two documents, review them, and make sure they are consistent with one another and they can easily be used in conjunction with one another. So that's something you're going to want to familiarize yourself with. Look at your charter. If you are a charter municipality, you have some greater flexibilities than maybe a statutory city has. So review your charter, see what your charter says if it's applicable, and how that may be used to make your lives a little bit easier on the Civil Service Commission. Because there are going to be specific provisions in there. And sometimes when they do their charter review, there may be revisions that come out of the Charter Review Commission that are approved by the electorate that may require you to periodically update your rules. So that's something you want to look at. Civil service law itself, Chapter 124 has a lot of information in it. There's probably a lot of things in there that you wouldn't think would be in existence or considerations, but that's the nice thing about public employment. There's a lot of statutory provisions to make sure that it is for merit and fitness. So review Chapter 124. See what the law says the requirements are. What can we deviate from? How can we deviate? Can we deviate at all? And again, you're going to want to talk with your legal advisor about how, if at all, you can deviate. But there are certain municipalities that are going to have greater flexibility than others. So check Chapter 124. All the things that we spoke about today are outlined in Chapter 124 of the revised code, along with some other things that may, again, provide some kind of guidance or direction as to where you may want to go with your rules. Similarly, there's an administrative code out there that has some provisions that you may want to consider. In addition to the things that we talked about today, you may want to look at some of these administrative rules about how are we doing our hearing process? Are we going to limit the number of witnesses? Are we going to have any pre-hearing filings? Are we going to, how are we going to rule on evidence? All those different types of things you may want to look at the administrative code on, or even SPBR's rules to see what it is that you may want to put into your local administrative rules. Because again, there's a lot of really good information out there that is designed to make, I wouldn't say make your life easier, but certainly make the hearing process more efficient and make sure everybody understands what the dual responsibilities are throughout the process. So that's something you want to consider. Again, flexibility and review, we've covered all of those, but I've dealt with commissions that have had rules that are this thick and that are this thick, varying levels. So whether it's 2 inches thick or 15 pages, there's really no right or wrong answer, but you just want to make sure you have rules that are appropriate to allow you to do that which you are supposed to do. And to do that, you're going to have to review it periodically and check and see what works or what issues you've had in the past. Lastly, resources. A word about resources, because there are a lot of them out there. Many of them I've already touched upon. So I'm not going to go over those again. I won't go over the SPBR Chapter 124 of the Ohio Administrative Code. I apologize for the duplication. But make use of your local law director. Make use of, if you have an outside special counsel advising you, talk with whoever your liaison may be to the city. Try to see what issues they're dealing with. What is it that can be done to make running the municipality, I don't want to say easier, that's probably not the right word, but allow them to do that which they're supposed to do. So talk with those individuals. Talk with Civil Service Commission members from other municipalities. Reach out to them. See what works for them. See what doesn't work for them. With the internet nowadays, many times many municipalities have their rules on a website. So check out their website, see what your neighbor's doing, see what rules they have. The other thing to do is, check the local newspaper, check the local news if there's anything that's being appealed, because your decisions can and will be appealed at some point to a local common pleas court. So look and see what's going on out there that may impact that which you want to do. So use those resources at your fingertips, again, to make your time on the Civil Service Commission a pleasant one, something that you don't dread to participate in. And quite honestly, during the duration of your term, or if you serve more than one term, make sure that it's something that you enjoy and appreciate doing. I know as a practitioner that many times often appears before a Civil Service Commission. I certainly appreciate the time and effort that people put into that. It's not always easy. It's not always pleasant. There may be other things going on. Sometimes it's a really nice day or a really nice evening and you have to sit through a hearing. And it's frustrating, and I get that. So try to do that which you can do to make your time on the commission a pleasant one, if nothing else. So with that being said, that covers the information I have prepared. I appreciate the time, and thanks to the State Personnel Board of Review for having me.